Hi everyone, this is Daniel Tekunoff. In this video, we're going to look at 4 landmark Article 5 cases of the U.S. Supreme Court that were written and published from 1920 through 1931. These are the 4 cases: Hawke versus Smith, which was a 1920 case; Dillon versus Gloss in 1921; Lesser versus Garnett in 1922; and United States versus Sprague in 1931. These cases bridge back to the McCulloch versus Maryland case and the original constitutional record. There really aren't a lot of cases dealing with Article 5 in all of the Supreme Court history, and so it's a great area to study because you don't have to study as much. And then going forward, these cases bridge to the modern day term limits cases: U.S. Term Limits Inc. versus Thornton, a 1995 case, and Cook versus Gralike, a 2001 case. The first case, Hawke versus Smith in 1920, picks up where McCulloch versus Maryland left off and restates the fact that the Constitution was ordained by the people, and when ratified, it became the Constitution of the people of the U.S. This case, Hawke versus Smith, was about the state of Ohio trying to replace the rules in the Constitution about ratifying a constitutional amendment. They wanted the people to directly vote to ratify, and the court said they couldn't do that because the language of the Constitution specifically gives that power to the state's legislatures. The court goes on to say that the states surrendered to the general government the powers specifically conferred upon the nation, and the Constitution and laws of the United States are the supreme law of the land. The framers of the Constitution realized that it might, in the progress of time and the development of new conditions, require changes, and they intended to provide an orderly manner in which these could be accomplished. To that end, they adopted the 5th article. As the court states, Article 5 provides that amendments can be proposed by 2/3 of both houses of Congress, but they cannot be proposed directly by the state legislatures. Instead, the state legislatures apply for a constitutional convention per Article 5, and those delegates are elected by the people. And it's important that the body has deliberation and consideration. This is the free mind working to come up with the best solution. So it's very important that you have a convention where the people are free to talk and free to change their minds. Here, the Hawke versus Smith court simply states what Article 5 states, that changes can only become effective after ratification, either by legislatures of 3/4 of the states or by state ratification conventions, 3/4 of those in the states. And it is Congress who gets to choose whether ratification will take place in the legislatures or in special state ratification conventions. And again, they emphasize this point that both methods of ratification call for action by deliberative assemblages representative of the people. In other words, the state ratification conventions are composed of delegates elected directly by the people for the special purpose of discussing that constitutional amendment or amendments. And it would be the same in the proposal convention under Article 5. And of course, this would be the most direct expression of the voice of the will of the people. Here, the Hawke versus Smith court is talking about ratification of a constitutional amendment. But understand that this same line of reasoning would also apply to the actual proposing of the amendments in the actual Article 5 convention, that the power to propose constitutional amendments is a grant of authority of national power, specifically granted by the Constitution. And so it is not a power that the courts or either the U.S. Congress or the state legislatures have to alter the ratification method. They also would not have the power to alter the proposal method, and if no proposal method is stated, they do not have the power to fix it in the first instance. So the state legislatures do not have the power to limit the topics that can be discussed at the Article 5 convention. the court goes on to confirm a point that was decided way back in 1798 in a case called Hollingsworth versus State of Virginia, that constitutional amendment is not an act of legislation. And so the rules regarding legislation in Article 1 will not apply to the Article 5 process. The court here continues to just emphasize that the power of proposing a constitutional amendment to the federal constitution has its source in the federal constitution. The act of either ratification or of proposing that amendment derives its authority from the federal constitution. So the states' constitutions and laws cannot prevail over the supremacy clause in the U.S. Constitution. And here the court makes maybe one of the most important points, that if you had different rules across the nation, you would have endless confusion. And it's very important for the nation to have uniform rules in this area. This is what allows people to feel like they're part of a nation. The next case we're going to look at is Dillon versus Gloss, a 1921 case. In this case, it was challenged whether Congress could place a 7-year limit for ratification of a proposed constitutional amendment. The court found that it was within Congress's power and sets forth a statement that gets confirmed in the modern day term limits cases, that Article 5 is intended to invest Congress with a wide range of power in proposing amendments. Obviously, since the people delegated the power to amend government to Congress, that when the people themselves are sitting in constitutional convention, they themselves also have a wide range of power in proposing amendments. To the extent that the people limit the government, the people do not limit themselves. The next case is Lesser versus Garnett in 1922. In this case, there was a challenge to the 19th Amendment granting the women the right to vote on the claim that because this extended the right to vote as much as it did, it required the state's consent. The court rejected that argument, and it reemphasized again that the function of a state legislature in ratifying a proposed national constitutional amendment is like the function of Congress in proposing the amendment. It's a federal function derived from the federal Constitution, and it transcends any limits sought to be imposed by the people of a state. So it's very clear from this statement that the state legislatures do not have the power to limit the power to propose constitutional amendments. The last case we'll cover on this video is United States versus Sprague, a 1931 case. In this case, the parties were arguing that the 18th Amendment was not valid because it was ratified in the state legislatures rather than state ratification conventions. They made a proper argument that, according to the theory of free government, a constitutional amendment should be approved by the citizenry in ratification conventions where the delegates are directly elected for that special purpose. But the Constitution compromises the theory of free government and, in fact, allows another path. And so, therefore, the court disallowed the claim. Perhaps the most interesting part of the United States versus Sprague case is what it advises. It very clearly states that until that article is changed by an amendment, Congress still has the power to choose the mode of ratification. If we think that is wrong, then we have to change Article 5. So that may be what we want to start considering. For further study, I invite you to take a look at my book, Guide to the First Article 5 Convention of the People.